Good afternoon, everyone. Welcome to the June 25th Grant Eligibility and Support Committee meeting. I'm going to ask Shannon if you can do the housekeeping.
Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Grant Eligibility and Support Committee meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference. Per Bagley-Keene requirements, all cameras must be kept on for the duration of the meeting. If you are unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of your surroundings behind you. All committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select Live Transcript at the bottom of your Zoom screen, then select Enable Auto Transcription. Thank you.
Thank you. Would you mind taking roll?
I can do that. Connolly? Gonzalez?
Here.
King?
Here.
Klein?
Here.
Pryor?
Here.
Stalker?
Here.
Galkin?
Here.
Our advisors, Justice Rodriguez, Judge Wayne Gutierrez. Go through our liaisons. Selena Copeland from LAC.
I think she's in the process of joining, as I can see.
Lauren Klein from LAC. Zach Newman from LAC. Melanie Snyder from the Judicial Council.
Nicole Claro, I'm here for the council today. Thank you.
Great, thank you, Nicole. And I'll just take note of State Bar stuff. Thank you.
All right, we will move on to public comment. If there are members of the public who wish to comment about any item on the agenda, we'll confirm for 3 minutes for each of those. Just a brief note about public comment before we open it up to see if there is anyone. I would ask that you limit your focus on comment to items that are on the agenda or relate to matters within the Grant Eligibility and Support Committee's purview. Specifically, the Legal Services Trust Fund and its committee exercise oversight over funding for free civil legal services for indigent Californians. Thank you. And now let's see if we have any folks who want to make public comment.
There's no one with their hand raised.
All right.
I'm sorry, one person just raised their hand.
Okay, well, we'll start with them. I think that's Miss Anderson-Smith.
Hi, good afternoon. My name is Tamika Anderson-Smith. I'm the Chief Operating Officer and Interim CEO at Dependency Advocacy Center. I wanted to make public comment on agenda item 5.3, I believe it is. I appreciate the opportunity to speak in support of our request to submit a late 2027 IOLTA and EAF application, and just to add some quick context to the record. While preparing our 2027 application, our board voted on April 20th to dissolve our organization, citing rising caseloads, staffing gaps, loss of key leadership, and significant county funding cuts in Santa Clara County. Out of respect for the State Bar's time and resources, we made the decision not to apply for funding we believed we would be unable to accept. Missing this deadline was not an oversight. It was an intentional decision made under extraordinary circumstances. On May 1st, at the board's request, I stepped in as co-CEO alongside of longtime COO and founder Preethi Mishra, and we began the process of dissolving the organization with dignity. The week of May 25th, our county funding partner approached us with a proposal to remain open at reduced funding, recognizing what a monumental loss DAC's closure would mean for the entire Santa Clara community. They found a way to keep us funded enough to continue, although we still had to lay off several employees and end a very large program. We have been a compliant IOLTA and EAF recipient since 2019, and this funding has allowed us to expand our services for our clients in crucial ways. Losing it now, on top of the staff and programming we've already had to scale back, would be a significant setback. We deeply respect that this is a very unusual ask, but we request that you make an exception so we can continue our zealous representation for Santa Clara families during an ongoing child welfare crisis. Thank you again for all of your support and this consideration.
Thank you. Do we have any others? I don't see any hands.
No other hands.
All right, in that case, we'll move on from public comment. And I'll give an oral report as chair. So welcome everyone, glad to see all of you. Just a reminder for our role, the Grant Eligibility and Support Committee is charged with ensuring comprehensive oversight and support of grantee compliance across all Legal Services Trust Fund Commission grant programs, while maintaining consistent standards and promoting accountability. We have a few items to address today. First is approving the 2026 CARE Court grant for support center applicants, as well as the amounts to be allocated to qualified legal services projects and public defender offices in the second year of their 3-year grants. Second, recommending to the Trust Fund Commission that currently unfunded IOLTA and EAF applicants be found ineligible for 2027 funding. So there are some to discuss there. And recommending to the Legal Services Trust Fund Commission that it deny a request to reopen the 2027 IOLTA EAF application to allow for late submissions. The July 30th GES committee meeting will address ultimate IOLTA EAF eligibility questions before reaching the full commission. So we have that to look forward to. With that chair report completed, I will pass it on to Erica to provide a staff report.
Thank you, Jason. I just have a quick update. I know that at the last committee meeting, we had discussed sort of the beginning of the IOLTA EAF application process and the likelihood that we would be convening several eligibility review conferences with applicants this year. So I have an update on that. We had one currently unfunded organization, the Coalition for Humane Immigrant Rights Los Angeles, that we had previously informed the committee we would likely hold an ERC with this organization, but they recently informed us that they intend to withdraw their application. So we have canceled that ERC, and we have 4 others scheduled during this review cycle. So 2 have already taken place, one with the Center for Human Rights and Constitutional Law, and one with the Coalition of California Welfare Rights Organizations. Both of those ERCs took place last week, and then we have 2 remaining ERCs with a new applicant called Vidas and one with an existing grantee, the Wage Justice Center. Those will take place within the next 2 weeks. So staff and the assigned working groups for these ERCs will have an opportunity to present their observations and recommendations at this committee's next meeting on July 30th. In advance of making a recommendation to the full commission regarding eligibility for these organizations. So just wanted to take the time to thank those who have participated or will participate in these important meetings, and we look forward to sharing the results next month.
Great, thank you, Erica. Our next item is approval of the May 21st, 2026 open session meeting minutes. I would welcome a motion to approve those or any comments or feedback on the meeting minutes.
I'll move to approve.
I'll second.
That's Stalker moving and King second. Can we do a roll call vote, please?
Connolly? Absent. Gonzalez?
Yes.
King?
Yes.
Klein?
Yes.
Pryor?
Yes.
Stalker?
Yes.
Galkin?
Yes.
6 yeses, no nos, the motion passes.
Great. Moving on to business for today. We have 5.1, approval of the 2026 Care Court grants and amounts for county public defender offices and QLSPs, subject to the Budget Act of 2026. And I'm going to invite Lana to present, and I see her here. Welcome.
Hi, thank you. All right, good afternoon. My name is Lana Martin, and I'm a senior program analyst in the Office of Access and Inclusion, and I'm here to present scoring team and staff recommendations for the 2026 to 2027 CARE program. As we know, the State Bar administers funds for the Community Assistance Recovery and Empowerment, or CARE Act program. Per the CARE Act, all 58 counties in California are required by law to provide care court services to participants who are called respondents in the care court program. The CARE Act provides an attorney for each respondent free of charge. And if respondents counsel is available from a qualified legal services project or QLSP, that attorney is first assigned. And if respondents counsel through a QLSP is not available, the court must appoint a public defender. With that context, since 2023, each state fiscal year's Budget Act has provided that the Legal Services Trust Fund Commission administer funds to Respondents Council, both the QLSPs and the county offices, and provide to support centers or other entities that can provide training, support, and coordination for the Respondents Council. The Budget Act of 2025 did introduce a different approach to structuring these awards. It required issuing 3-year funding commitments to QLSPs and counties. So in 2025, the State Bar requested 3-year proposals from QLSPs. However, for support centers, the Budget Act retained that 1-year award cycle. So in 2025, last year, the State Bar awarded funding commitments to 4 QLSPs and also the 1-year grants to those 2 support centers. We're approaching a new state fiscal year starting July 1st, and the Draft Budget Act of 2026, which is currently Assembly Bill 109, provides that 2nd year of care court funds for the 4 QLSPs and the public defense offices, the county offices. It also allows the commission to issue another cycle of 1-year awards to support centers or other entities that provide training and technical assistance. To comply with Budget Act language, the State Bar structured CARE Act funding kind of in 3 categories. Discretionary grants issued to support centers on an annual award cycle, discretionary grants to QLSPs, which again are with 2020 Draft Budget Act 2026 language, providing year 2 of that 3-year award cycle, and then formula-based funding agreements to public defender offices or the equivalent off county office. Continuing on from the prior state fiscal year, AB 109 provides the same level of funding for 2026. The State Bar can grant up to $788,000 for support centers or other entities. $275,000 may be transferred to the Office of the State Public Defender. And as with last year, any remaining funds from the training and technical support category default over to Respondents Council. So this year, staff made technical updates to the RFP, the request for proposals, and requested proposals from support centers and other entities. So 2 support centers submitted applications for 2026 funds. They both had awards last year. This is Disability Rights Education and Defense Fund and Immigration Legal Resource Center. The scoring team was comprised of 2 commissioners and 2 staff. The team followed the same procedure and used the same rubric as last year. Among other criteria, the scoring team evaluated the 2 proposals for their ability to support Respondents Council with legal training and technical assistance, and upon request provide co-counsel, and also to facilitate a meaningful evaluation of their services and to appropriately administer public funds. All right, so both support centers proposed to provide similar services as in prior years, DRED-F since 2024 and ILRC since 2025. So the scoring team awarded a score of 88.75% to Disability Rights Education and Defense Fund and 80% to Immigrant Legal Resource Center. So both scores are above that 70% cutoff to be eligible for funding. Both support centers requested a slightly larger award size this year, which the scoring team found reasonable given general increases in operating costs and also their proposed scope of deliverables. And so the scoring team recommends awarding the 2 grants at the full amounts requested, which you can see here on the slide. So that was award recommendations from the scoring team for support centers. So this, now we're moving over to staff recommendations for amounts for Respondents Council. So again, the Draft Budget Act of 2026 provides a baseline of that 15,750,000 for Respondents Council, and with the recommended amounts for support centers totaling about 156,000. After transferring that 275,000 to the Office of the State Public Defender, we have this figure, $16,106,154 available for public defender offices and QLSPs. So the state bar would then uses a formula to develop county allocations, and the formula divides each county's general population by the total population statewide. There are also several minimum funding floors to raise allocations for those counties with comparatively small populations. And again, same as last year, county funds, each county's allocation first goes to any QLSP serving that county, and then any remaining funds go to the public defender office or equivalent. We do want to note that while the county offices and QLSPs have 3-year agreements, the amounts for years 2 and years 3, or year 2 and year 3 may differ from those awarded in 2025. And this is because a county's general population might change year to year. And also the amount awarded to support centers may change. So AB 109 does limit any reduction to county offices or QLSPs at no more than 25%. So using the approach that we just described, staff recommend the following amounts for QLSPs for year 2 of their 3-year grants. 2 QLSPs have funding commitments that share county allocations with public defender offices. That's Legal Aid Society of San Bernardino and Legal Aid Society of San Mateo County. So in accordance with AB 109's provision that county's funds first be allocated to any QLSP serving that county, staff recommend maintaining their 2026 allocations at the same level as their 2025 allocations. In San Francisco County, however, 2 QLSPs have funding commitments that share the entire county allocation, so no funds are diverted to the Public Defense Office. And this is Justice and Diversity Center of the Bar Association of San Francisco and Legal Assistance to the Elderly. So the 2026 county allocation, general population for San Francisco is about reduced by about 30,000. So the allocation is about $3,500 lower than its 2025 allocation. So staff recommend using a pro rata approach to reduce each of those QLSPs amounts based on its respective share of their 2025 allocations. And this approach results in a decrease of about 1.7 thousand each for JDC and about 1.9 thousand for LAE. And then after awarding funds to the QLSPs, we provide a table in the memo that describes the amounts that the staff recommend making for the public defender offices. All right. With these recommendations, I'll pause here and put the resolution on the screen, and I'm happy to take any questions about recommended awards or amounts.
Lana, is the budget at all controversial in the legislature? Is this something anybody's paying attention to?
If you want me to, unless you want to answer it.
You can, Dawn, yeah.
It's not controversial, but one thing we have noticed is that there has been a large amount of unspent funds. Lana's actually trying to collect those funds from we know that they haven't spent them, so we've invoiced the public defender's office. So we are going to be remitting between $7 and $8 million. So it's a sizable portion for 1 year. So I think that will probably raise the flag, but up till this moment, no, there hasn't been controversy.
Thank you, Dawn. Any other questions?
Seeing none, would anyone be so kind as to make a motion to approve the proposed resolution?
So moved.
Okay. I'm not
Second.
fast enough. I'll second again.
Klein, then King. Thank you.
Thank you. Connolly, absent. Gonzalez,
Yes.
King,
Yes.
Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Galkin.
Yes, but I have to abstain as to Legal Aid Society of San Bernardino.
Noted, thank you. 6 yeses, no nos, the motion passes.
Thank you. All right. As I believe folks heard and as indicated on our agenda, 5.2 was withdrawn. So we're going to move on to 5.3, which is action on 2027 IOLTA EAF application missing required pre-application. And Erica, I would invite you to present on that.
Thank you. Yes, so this agenda item has to do with our new pre-application process that folks may or may not be familiar with. So staff, just to give some background, is in the midst of interest on lawyers, trust accounts, and equal access funding application review. Every year we conduct this review from approximately mid-May through late July. So we have about 10 to 12 weeks to review applications, which this year we received 122. So this is a pretty tight timeline for staff given the length and complexity of the IOLTA and EAF applications. And we've seen an increase in applications from new applicants in recent years, which is wonderful, but we have found review of those applications tend to be more time consuming and somewhat difficult when folks are new or unfamiliar to the process and the governing authorities and some aspects of the application. And so having had a number of instances where perhaps the normal application review process didn't feel particularly comfortable for staff or the commission when it came to some of these newer or unfunded applicants. The commission in November of 2026 passed a resolution that beginning with this 2027 IOLTA EAF application, we would implement a pre-application process. So staff undertook that and developed a pre-application that was released in January of 2026 and due in February. It is a required element of the application process for any organization that's not funded. So either they're new in terms of first-time applicants, or they may be former grantees who have had a break in funding. And so we view this process as an opportunity to help staff issue spot concerns with the application, challenges or risks to eligibility for funding, and it gives us sufficient time to work with that applicant to provide technical assistance, to clarify any significant questions that we can see based on the information that we're seeking, which tends to focus on elaboration on what their program services are and some of their financial information. So it's essentially a snapshot or a preview to what you would receive in the full application. So we implemented that this year. The pre-application, as I mentioned, is required, but it's not binding. So an organization that completes a pre-application, but staff feels, for example, if we feel that they may not be eligible, that's not a binding decision on the organization. They can still proceed to the main application as long as they submitted their pre-app. It's ultimately going to be the commission's decision to make that determination. So we had one organization this year, Housing Equity and Advocacy Resource Team. They are a former grantee. They stopped receiving funding after the 2020 grant year. They submitted a main application in May, but we didn't receive a pre-application from this organization. And we also, when we haven't reviewed the full application, but sort of a cursory review of the application revealed that they also failed to submit an audited or reviewed financial statement, which is a required part of their application, and was due on May 1st. So staff did reach out to this organization to sort of inform them that we were lacking both of these elements. The organization just recently replied to us and said they understood that these are barriers to their application. But we did need to bring it to the commission because the application has not been withdrawn. Because they failed to do the pre-application and then the audit, which is an inflexible requirement, and under the state bar rules, an unfunded applicant cannot get an extension to an audit deadline past the application deadline. Staff is recommending that this organization be recommended as ineligible to the full commission for this application cycle. There is no negative implications for the organization to apply in the future, and we welcome them to be in contact with us now that we've been in touch. We didn't realize that the organization was going to submit an application. I believe they opened this application in our grants administration system the day before it was due, and we only saw that they were completing one the day it was due. Had we seen activity there, because we would periodically check to see who had opened an application, had we seen that earlier in the process, we certainly would have reached out to them to have that discussion sooner. But because we didn't know until the day it was due that this organization was intending to submit an application, they unfortunately did go through the process of completing it, even though, as I've mentioned, these are kind of the two aspects that are prohibitive to proceeding with their request. So staff's recommendation is to recommend that HART be found ineligible for 2027 IOLTA EAF funding. And I'm happy to answer questions about that, if any.
I will just say, as chair, when I first talked to Erica about this, and we were talking through I found it notable that the thing that was missing is exactly why we have the pre-application process, to help them ensure those things aren't missing. So it's not like a procedural miss. Like that's a procedural miss that actually resulted in a pretty significant miss on the application, which could have been avoided had we done the procedural thing, right? So I found that pretty significant myself. Any questions? I don't think we have any questions. Oh, Angie, go ahead. You are on mute.
Sorry. Did they know that the process had changed and there was a pre-application requirement since they'd previously been funded through the regular process?
Right. I don't think they were aware of the pre-application. I believe we did have, so we reached out to folks that we knew affirmatively were interested in applying, who we had been in contact with. And we were in contact with them sometime in 2025 prior to a pre-application being contemplated. But at the time that we had that conversation, they weren't even sure if they wanted to move forward. We're just kind of re-exploring whether they would be eligible and wanted to go through this process. And then we hadn't heard from them again in the months leading up to this application. So we had not been in touch with them about the pre-application.
So what you're saying is that the last conversation you had was prior to the requirement, and they didn't have any contact with you until the day they put in the application. Okay.
Yeah.
Sorry, I'll also add when we issued the pre-release requirements, pre-application requirements, we also updated the State Bar website for visibility and as well as the Smart Simple homepage. So that language has been updated. Our eligibility guidelines also reflect the pre-application requirements. So had the organization reviewed all of those documents prior to submitting, and we tried to make it as visible as possible. But again, because we didn't have a continuous conversation with them, that's the best way to communicate this new update requirement.
Okay, so no questions. Do we need a resolution, Erica, or a formal vote on that?
Yes. I am happy to read the resolution that was in the memo if that's helpful, since I'm not sharing a PowerPoint.
I have the memo, but it might be helpful to anyone else who doesn't have it up in front of them to read it out.
Sure. So the recommended resolution is resolved that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee recommends that the Legal Services Trust Fund Commission find currently unfunded applicant Housing Equity and Advocacy Resource Team ineligible for 2027 interest on lawyers' trust accounts and Equal Access Fund funding.
Thank you. Would anyone be interested in making that motion for
So
that
moved.
resolution? Judge Klein?
I will second.
I think I heard prior second first.
Thank you. Connolly, absent. Gonzalez,
Yes.
King,
Yes.
Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Galkin.
Yes.
6 yeses, no nos, the motion passes. Oh, Jason, I think you're muted.
Oh, sorry. Moving on to action item 5.4, action on request to prepare and submit late 2027 IOLTA EAF application. Erica, and this is you again.
Thank you. So this item has to do with request from Dependency Advocacy Center on submitting a late 2027 IOLTA EAF application. And as you heard during the public comment, DAC is an existing grantee receiving 2026 IOLTA EAF funding. IOLTA EAF applications were open from April 3rd through May 15th this year, so they were open for approximately 6 weeks in the spring. DAC informed us on April 27th, which was about halfway through that period, of their intention to cease operations, most likely around August 31st of this year. And then we received an update from them about a month later, which was 2 weeks after the close of the application period, to inform us of the additional funding that they mentioned from the county that became available to them, and submitting their interest in applying for next year's funding. They informed us at that point that if we were able to reopen the application for them, that they felt they could turn around an application within about a week. All told, in terms of the time since the application closed to when they would have been able to submit it, it would have been about 3 to 4 weeks into our 10 to 12 week review process. So the commission, in terms of considering late applications, can consider a variety of factors, one of them being how late the application is submitted, the completeness of the application, the reasonableness of the explanation for the delay from the organization, any mitigating factors, and any pattern of late submissions. So with this organization, staff observed the fact that, being an existing grantee, DAC did have the opportunity to complete an application if they felt that there was a likelihood or even a possibility that they might be able to continue operations for 2027. We do have a lengthy application period to allow organizations sufficient time to fulfill all the requirements. It's not to say that an application couldn't be completed in a week, but what often happens, even with applications submitted on the normal timeline, is that there is often a certain amount of dialogue that then takes place after receiving the completed application between staff and the organization to clarify any omissions, any questions that staff might have, to ask for updates to the application, to clarify certain points, or to provide more detail to support the application. It really depends, but in terms of how much follow-up is needed on an individual application, but it can take several weeks depending on the application and the condition it's sort of received in. And so the staff was mindful of that in terms of impacting our timeline for review. And also just the number of applicants that we receive in a given year, as I mentioned before, it has been increasing every year. And so anytime that there is a delay with an individual organization, it can impact the staff review and our ability to do a comprehensive assessment. We are also mindful of the fact that making an exception in this instance may be setting a precedent that could be challenging given the number of other grantees that we have if there was a similar situation were to arise. We're certainly sympathetic to Dak's situation and circumstances, but it was staff's feeling that if they wanted to essentially keep that open or have that contingency option, that it would have been more appropriate to submit an application and then maybe have that conversation with staff about whether to hold off on reviewing it or whether they might want to withdraw an application, because that would certainly be their option as well if they decided that they couldn't continue. But given sort of on the whole, staff is recommending not reopening this application to allow late submission.
Can I ask a clarifying question, Erica? When there have been late submissions in the past, how late have we previously let that slip into? Noting that the period of review, like it's 12 weeks, I can't imagine we go that deep into late submissions regularly. So I'm just curious if you have information on that.
Yeah, so what I have personally seen in the past is, one, we've seen decreasing rates of late applications, which is great. A lot of the ones that come in are usually the same day. It might just be a few hours later if folks are having a technical issue or something wasn't loading correctly. And then you might have a handful that are a couple days late. And there is typically an explanation for that, or we're, proactively informed of what the challenge is. I can think of one example in recent memory. I think the organization was about a week late. I unfortunately don't remember what the explanation was, but in terms of getting into 3 or 4 weeks late, I have not seen that myself.
I can speak to that too, because I've been here a bit longer than Erica. I'm going on 11 years. It's not typical at all. What's more typical is late audit. Usually the organization is able to get in the application around this, what Erica's saying, within a couple of days. That if it's the same one, Eric, I'm recalling from Erica, there was an organization that was about maybe between 5 or 6, around that week mark. And their ED was very sick, and then they were having issues communicating, and then they were able to see that then within I think a day or two they were able to work on it. So it hasn't had this this lengthy of a delay.
Angie?
I know this isn't the process part, but it occurs to me they're currently funded. Can you tell me how much we give them and what percent of their total budget that is now? In other words, how big a difference is this going to make in their service delivery?
I can look up how much they're funded at right now, but
Because, you know, they had trouble getting funding, and probably that's why they didn't make an
Sure.
application to us, because they weren't sure they were going to be around. And
Right.
I'm just kind of curious how that all meshes with them continuing, if this is the make or break between them having not be able to provide any services, it kind of makes an exception.
Sure. I don't know the percentage of their overall budget, but my understanding was that we were not necessarily the majority of their funding. Let's see. It looks like last year it was about 600,000. Yeah, a little over 600,000.
Their total budget or our
No,
portion?
how much funding they're receiving from the state farm.
Oh, well, that's considerable.
Mhm. And in terms of non-state bar revenue from 2023, which would have been from our last application cycle, they had 4.4 million in non-state bar revenue. So
They're a dependency program, so they get money from the courts to do their dependency work, and then then they get money from us too.
Enough money from us that it makes the difference?
Oh, I don't think we can answer that.
yeah,
Yeah. Okay. Thank you.
Without trying to steer any of our members one way or another, I think in this situation, while I understand the exceptional nature of the situation, right, and not knowing the county was going to show up with additional funds, that information was relayed to the state bar, from what I can see, basically like 2 weeks after the deadline had already passed, which means that even if they had the application ready to turn over at that point in time instantly, it's already an exceptional timeline beyond the deadline for what we would normally grant an exception otherwise. And I appreciate, as Erica stated and as the memo states, there's not a lack of sympathy for the situation. It's a tough situation. I just don't know that it's fair and reasonable to reopen after 2 weeks as opposed to reopening it like if it would have been in the normal window of like, oh, we found out right before the deadline. And I don't know that it's fair to staff from a review standpoint, from a facilitation standpoint, or to the other applicants, frankly. I guess that's my concern is we have a lot of other applicants all competing for slices of the same pie. So I guess that's my thought process, and the timing is unfortunate, but I don't know that it is a reasonable position for us to unwind that.
Well, one more thing. Do we know when they found out they had the other money?
I don't know the exact date, but my recollection is when they informed us, they said they had just found out. So
So they couldn't have applied any sooner anyway.
well,
You can still submit an
they could
application.
have, yes, they could have applied, and then, as I said, they could have withdrawn their application had they decided that this was not going to be, sufficient funding for them to continue regardless. But
Okay.
I mean, they were not prohibited from applying.
Right.
It was like it was a deliberate choice. So again, we understand that. We understand the reason why, but it's difficult, I think, from a staff perspective now to reopen it.
Any questions or discussion on this one outstanding? All right, hearing none. Erica, do you want to read off the proposed resolution and we'll see how that goes?
Yes, the proposed resolution is resolved that the Legal Services Trust Fund Commission, Grant Eligibility and Support Committee recommends that the Legal Services Trust Fund Commission deny Dependency Advocacy Center's request to access and submit a late 2027 interest on lawyers' trust accounts and equal access fund application.
Okay, noting the proposed resolution, I would invite a member to make a motion.
So moved.
That's Stalker. Do we have a second?
I second.
That's Pryor, second. We'll do roll call.
Absent. Gonzalez,
Yes.
King,
Abstain.
Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Falcon.
Yes.
5 yeses, 1 abstention. The motion passes.
Thank you very much. I believe that is our last action item. Erica, anything else before I adjourn the meeting?
Nope, I don't think so. Just quick reminder that our next meeting is July 30th, and we will be addressing the remainder of the IOLTA application questions that have arisen during review. So we expect that to be a fairly full meeting.
Understood. Thank you everyone for your participation. I appreciate it and wish you all the best this afternoon. Have a good afternoon. Thank you.
Thank you.
Thanks.